Okay, well, welcome everyone to the annual lecture for the Centre of Socio-Legal Studies for 2025. And my thanks to Wolfgang College and the Cluster for Law and Societies for hosting the event here. This lecture is an opportunity to invite an eminent international scholar to deliver a lecture on a subject that concerns the role of law in society. It could be any subject that sheds light on the nature and role of law in its social context, or of laws in contexts. The field extends to multiple societies and multiple forms of law. We haven't previously invited a scholar of international law, but Professor Koskenniemi is uniquely well suited to talk on this subject to our audience. He's had a long career as a diplomat, including as counsel for his native Finland in the International Court of Justice. So he has first-hand experience of the making and operation of international law in practice, the sort of knowledge that socio-legal scholars dream of. At the same time, he's had a distinguished career as a legal academic, as Professor of Law at the University of Helsinki, and Director of the Erik Castron Institute of International Law and Human Rights. He's led the way in critical writing on international law. His books such as From Apology to Utopia, The Gentle Civilizer of Nations, and To the Uttermost Parts of the Earth. This writing is historical as much as contemporary. He considers the development of international law firmly in its social and political contexts, and traces the development of the thought and ideas that have shaped it. So there's much that's of interest to a socio-legal audience, and beyond. These lectures are also the opportunity for us, as socio-legal scholars, to come into conversation with those from other departments and disciplines. There are many faces here I don't recognise. You must be from further afield, and you're all very welcome. So, Professor Koskenniemi, thank you very much for accepting our invitation to deliver the annual socio-legal lecture for 2025.
Thank you so much, Fernanda, for that lovely introduction. Thank you, Nadine, for all the practical arrangements. I'm exceedingly happy to be back in Oxford, especially because I'm back at Wolfgang College, where I spent a year, 82, 83, as a British Council scholar. I was then a young attaché at the Ministry for Foreign Affairs. But it may just be that year that I spent here, and I did a little degree that was then called Diploma in Law, that may have prompted me to try the academic career many years thereafter. I thoroughly enjoyed the college. I enjoyed getting to know English life a little bit. First, when I received the invitation letter, and on the cover of it, it was said that every student has an allotment. What on earth did that mean? I also remember having always had my feet wet, and I suppose that links to something that my present partner pointed out to me as she visited here. And she came out from the shower here at Wolfgang College saying, "Martti, there are mushrooms in the shower." and so I realized that it's now been renovated since then, and that must have been a good idea. So I'm an international lawyer, and international law is a big problem. Today I try to talk a little bit about efforts to bring international law down to earth, to insert it with some relationship to the social. International law is a field of legal formalism par excellence. Here is a famous for international lawyers, famous statement from the Permanent Court of International Justice from 1927, which defined international law in the way that successive generations in the academia and in some parts of international legal practice, especially those parts related to the United Nations, have understood it ever since. Namely, that the law is a law between states. It reflects the will of states. State can be only bound if it wills so, and that is it. This is a German understanding of international law, and I'm on record because having written an article with that title, that international law is a German discipline. It doesn't make it any worse. I am a great admirer of German public law, especially 19th century German public law. And I'm afraid that you will encounter during this lecture a number of dead white German males who I think in a serious way are responsible for the standard understanding of international law as a law of states created by the will of states, opposable only states that will so, and adjudicated in institutions such as the International Court of Justice. This world has a number of problems. Namely, it is descriptively weak. It speaks of a world in which countries would be sovereign equals, but the world obviously is a world of great substantive inequality. The understanding is morally questionable. Many have pointed that out because it tends to support a very etatist, a state-centric view, even extremely state-centric view, to the extent that a state can only be bound if it wills so. And there have been scores of lawyers who say, well, this simply means that international law cannot be binding, because whenever have you heard a state wanting to be bound when something is being opposed to it? And it's institutionally misleading because it directs attention to very marginal institutions, such as the International Court of Justice. How many cases has the court decided? Well, maybe 100, 120 cases after the Second World War. Who remembers them? Well, international lawyers, those especially students who are taking the exam, but very few thereafter. So it's a formalist structure. It is based on ideas of legislative power of the state, the subjecthood of the state as its practical, moral, and legal center. And many people have found that extremely problematic for good reasons. Now, this idea is based or follows from a conservative tradition, a tradition that began with the Napoleonic or post-Napoleonic Restoration, the Congress of Vienna, 1815. Here is Georg Friedrich von Martens, the professor of public law and international law at the University of Göttingen, the first professor with that title, who had written the first textbook of international law in which this understanding was put forward, namely that international law is not natural law. That Grotius, Vattel, and those 18th, 16th, 15th century men who thought so, who worked with the jus gentium based on speculations about universal human nature, were dealing with hopeless abstractions, which in the real world of great power policies in the 19th century no longer could be operated with. Instead, the law was to be condensed in principles followed by the practices of European states. It is in those practices of the states that a practical law, a meaningful law, may be found. Martens was a conservative, I said. He was a member of the Restoration and part of the elite that in the course of 1820s, 1830s, was being increasingly directed by what was then called, and later, the social question, la question sociale, which meant that groups of thinkers, especially French thinkers, but also others, were proposing that the most important questions of European life were not about constitutional order, but were about dealing with mass poverty, urban dislocation, labor relations, and what we would today call the rise of capitalism, the social question. Now, one lawyer who was interested in the social question was Lorenz von Stein. Lorenz von Stein, as a young man, like many young men, especially academics, traveled around Europe in the 1830s and early 1840s and found himself in Paris, especially during the July Revolution 1830. And he met men who we now speak of as Saint-Simonians, Fourier followers, and other early socialists. Not socialists in the way that we today understand, but men who were interested in the social and were engaged in trying to reform the conditions of labor and urban life in ways so as to eradicate social problems, problems of poverty, and so on. And he came back to Germany and he published two rather massive, and I find quite unjustly overlooked volumes on his experiences with his debates with the Saint-Simonians, the Fourierians, and the others. And he suggested that what he saw in operation was a Gesellschaft, society. And that Gesellschaft led him to speak about labor, interests, and even social movements. He noted that what was going on was a Klassenkonflikt, and class conflict, and that conflict was mediated and structured by the fact of some people having lots of property while other people had no property. Now, von Stein was not a Marxist, he was not a socialist, he too was a conservative. But what he was doing when he wrote these two volumes on his experiences in France was to try to convince his compatriots in Germany, especially in Berlin, but in other places, that this is what the Germans had better prepared for. It's there in France, and it's going to cross the Rhine, and we are going to be confronted with the kinds of demands that what he called social movements are going to put forward. A few years thereafter, he suggested that not only should we speak and think in terms of a Gesellschaft, but we should also imagine into existence Gesellschaftsrecht, a law of Gesellschafts, separate from the public law of the state, operating in its own manner, through its own rules, accepting its own principles, and so on. And of course, this didn't come true. Lorenz von Stein, later on with the liberal disappointments, returned or received a position in Vienna as a professor of Finanzrecht. But as an already older man, and as a professor in Vienna, he wrote a long essay in which he suggested that this thing, Gesellschaft, was expanding outside individual states. It was a Europe-wide phenomenon, and therefore what he saw people called international law. Völkerrecht, based on state cooperation, was insufficient to deal with that, and therefore he suggested that there was a Völkergesellschaft, an international society or a society of nations that should be dealt with by this new internationale Gesellschaftsrecht, international social law. Another German person, way more familiar in Germany, but also elsewhere, the most important public lawyer in Germany in the middle of the 18th century, Robert von Moll. Von Moll was a professor at Heidelberg, professor of public law, well-known liberal professor, specialized in the American Constitution and federalism. But he also was interested in the way in which the manners of life in different European countries were becoming more and more similar, that travel was increasing, that commerce was increasing, that what he called social associations were expanding over individual European nations. And he suggested in an article that there should be, in 1850, just after the 1848 revolution, that whilst the revolution in Germany and in other European countries as individual countries may have failed, but this European-wide social development is not going to end here, and therefore we need what he called die Lehre von den internationalen Gesellschaft, a doctrine of the international society. International society. And he elaborated on this nature of this international society in the way that 20th century Europeans and 20th century people in the developing world have been very accustomed to thinking in terms of what we would call globalization, the expansion of trade, commerce, industry, railways, telegraphs, and so on. Now, von Moll was not just some professor. He was also elected as one of the members of the Frankfurt Parliament in 1848. This is the crazy year in Europe. The liberal revolutions, one after another of the old regimes collapses, and liberal parliaments are set up, also in Germany. Von Moll becomes a representative in the Frankfurt Parliament, in the St. Paulskirche meetings. But not only that, he also becomes the Minister of Justice of the short-lived German Republic. Now, of course, the revolution is crushed. Many people have to take refuge in England, in Switzerland, in other places. Only few can return. Von Moll can. And after the revolution, he starts increasingly to write on this idea of an internationale Gesellschaft. We should think in terms of an international society, because the Moors of Europe are becoming no longer Moors of a single country, but many countries. This actually was part of a larger reaction among liberals, and especially left liberals in Europe, who established various means of collaboration to explore the idea of how could we think of this society thing in a scientific fashion. Can there be a social science, a science of the social? Here are some of the associations. The first one here in Britain, the Social Science Association, that had a number of committees dealing with specifically legal questions and international legal questions. This was also the time when international law as a professional discipline started to be established, so that the first chairs were being set up, such as the Cicele chair at this university in 1866. 1857, the Ewell chair in Cambridge in 1866. The first holder of the Ewell chair, John Westlake, was Secretary General of the Social Science Association and one of the founders of the Association Internationale de Progrès de la Science Sociale in Brussels later on, where he and other lawyers were trying to imagine how can we talk about the international society in scientific terms. And these many associations, of course, the German Verein für Sozialpolitik, very famous, very influential at various periods. Anathema. So a great opposition towards the very idea of the social emerged in Germany. German and especially Prussian nationalists like Heinrich von Treitschke were adamant that this thing should not spread. This idea should not spread. And so Treitschke, a well-known Prussian nationalist, friend of Bismarck's, an important intellectual operator in the unification of Germany, wrote his Habilitation on this idea of die Gesellschaftswissenschaft, ein kritischer Versuch, the social science, a critical analysis, in which he pointed out that there is no such thing as society. It's an imagination of these hopeless cosmopolitan liberals. What we have here are individuals especially individual Germans, and then our collective effort to create the state. To be satisfied with society takes the momentum away from what is the most important assignment for all Germans, namely to bring them together in a state. Therefore, we don't want to go forward with this idea. We leave it in the past as a liberal aberration. He wasn't the only one. Johann Caspar Bluntschli, one of the most important German-speaking lawyers from Switzerland, but then also a successor of von Moll in the Heidelberg chair, and the intellectual father, I don't have the time here to defend this position, the intellectual father of the new emerging discipline of international law. My book, The Gentle Civilizer of Nations, is about that process, the creation of international law in the 1870s. And I try there to demonstrate how the ideas and the activism of Bluntschli led to a group of men to recognize each other as international lawyers. And he also thought that this idea of society was a hopeless liberal utopia. There was no such thing. You could not scientifically study it. Instead, what you had was the state. He, of course, was a public lawyer. So for him, the state was a really concrete emanation of a human life. Hegel was helpful in bringing forward that understanding, and individuals. And that law was actually 100% of the law could be conceived in terms of public law and Menschenrechte, public law and human rights. And the relationship of those two was, as he put it, like the shoreline and the sea. So in some cases, public law and the state legislation, the regulatory aspect, the regulatory operations of the state expand, in which case the Menschenrechte, human liberties, are constrained. Or then there are more and more human rights, individual rights, civil rights, etc., in which case, again, the state's regulatory powers are diminished. There's nothing in between. Why should there be? And as a result, this understanding was taken into the profession of international law. It obviously also corresponded with the original conservative Martens idea, so that the international lawyers, when they met for the first time in 1873 in Ghent at the town hall on the 8th of September 1873, when they set up the Institut de Droit International, they could accept the proposal made to them by Bluntschli of passing a declaration that contained the statute of this new organization, Institute of International Law, in which they defined themselves as the juridical conscience of the civilized world. Conscience juridique du monde civilisé. Now, what I propose to you is that international law emerged, modern international law, from the activities of these men who were etatists, European etatists. They felt that the law that's now needed is a cooperative law among European states because they represented civilization. And that the necessary substantive background to the formal techniques that they understood that international law would not be any idea of international society. Instead, it would be this idea of civilization. Civilization, society. What's the difference? Well, at least one difference is that when we speak in terms of society, our imagination is horizontal. Everybody, we all live there. When we speak in terms of civilization, our imagination is vertical. Here are the civilized, here are the not so civilized. And of course, international law, as it arose in the late 19th century, arose among the second wave of European imperialism, the scramble of Africa, the new international lawyers, men who for the first time imagined themselves as international lawyers, sat in the delegations of the countries in the Berlin Congress in 1885, called by Bismarck in order to settle the scramble of Africa. And these men wrote the final act and the rules of the scramble. And they did participate also in the various multilateral conferences of late 19th century, the Hague conferences, etc., and thereby institutionalized themselves and their presence in the foreign administrations of various countries. In this book that I mentioned, The Gentle Civilizer, I've tried to trace how in the different European countries from 1873 onwards, one after another, a new position of legal advisor, public international legal advisor, was established, and those people would then manage this new field of international law in this etatist mode. Now, here's another dead German who is really worth of taking very seriously because of how we understand public law and international law today. Georg Jellinek. In his great Die allgemeine Staatslehre, the general theory of law and state, as it's translated badly, allgemeine Staatslehre, Jellinek takes on the ambition of trying to put forward two kinds of science. One is two kinds of science of state. One is a social science of statehood, situating state in the social milieu in which different states emerge. They receive their identity, where their constitutional orders and indeed their political systems differ, owing to the histories of the nations that they embody. So this is the social science of statehood. And he sketched in the latter part of that very thick book the legal science of statehood as well. And he insisted that any syncretism, any hybridity is a perversion. The line between the two has to be drawn very clearly and kept in social science. He thought for there to be a science, there will have to be a method. And the method has to be autonomous for the science to explain itself as something separate from the already existing sciences. And he suggested that law as science is about the state will. Legal science is a science of norms that does not teach us how things are, but how they should be. Not how they are, but how they should be. And how they should be is received from what states will. So it's voluntarism, it's formalism, it's disappointing. But Jellinek, as the most brilliant German lawyer at the time, recognized that there were two problems here. One of the problems was that it seemed to be the case that for a state will to be acceptable, it should also embody something he called legitimität, legitimacy. And he said, and put forward a cliché that lawyers have, especially public lawyers have repeated always, that there is something that can be explained as die normative Kraft des Faktischen, the normative power of factual. And again, he recognized this, both legitimacy and the normative power of the factual press against the boundary of this idea of law as merely the expression of state will. Is the will legitimate? What is the power of reality that creates that will, that makes those people the representatives of that will? Jellinek was in conversation with two other men during his career. I mean, he was in conversation with many people, but we're interested in two men who were in the same project as Jellinek himself. During his time, Jellinek began his career in Vienna. His first books were written there, especially his book on the law of federations, and another one on the legal nature of state treaties. But he had to leave Vienna because of the anti-Semitic attacks targeted against him. He could not get a chair because the Viennese press pointed out that it's inconceivable that European international law would be taught by a Jew. And so he went to Heidelberg and immediately received a chair of public law and befriended himself with this person, Max Weber. But already in Vienna, he had been speaking to that person, Karl Menger. Karl Menger, known as one of the founders of neoclassical economics, had written in 1883 this work, Investigations into the Method of the Social Sciences. Well, that was exactly the same project that Jellinek was engaged in. What is the method of social science? How do you deal with it? And Menger suggested that society should be understood as a collection of individuals propelled to move about in their environments by the effort to fulfill their needs. And that any law or any statehood, any kind of formal arrangement that emerges between those individuals looking to fulfill their needs is merely an unintended side effect of that push that we now recognize is the push of the Homo economicus. Jellinek wasn't satisfied with this, that his public law was merely the unintended side effect of something. Obviously, he wanted to think it as something more. He accepted that states are not real individuals. He also was critical of the organism theory. States are not live organisms, but states are important as legal constructions, and law is about making that construction and deriving conclusions from that construction by thinking human beings. It's not an unintended side effect of something else. In his studies of possibility of social science, Karl Menger critiqued famously the German historical school. Menger said, oh, well, history can never be a science, nor can economics be studied scientifically through, like Mosler and other economic historians or members of the historical school had tried, because history consists of individual events. And the science is about universalizable, general events, not individual events. And so, in a series of tortured chapters, he came up with this idea of the ideal type. And then Jellinek, in his first book on federations, he had been struggling as to, well, how do I... So there is the United States, there is Switzerland, there is the German Federation. How can I say anything general about federations? Well, he thought the ideal type might be a way to think of federations in a scientific way. And then he landed in Heidelberg, where the younger colleague, Max Weber, thought that this is an interesting idea and also went through with it. Both Jellinek and Weber, however, disappointingly accepted that law, in order to have its own single identifiable method, will have to be understood in a formalistic way. So Weber says law is the correct meaning of a legal proposition. Lasse Oppenheim, a professor of international law in Cambridge, German-educated, originally criminal lawyer, the most influential publicist in international law in the 20th century. When I came to the foreign ministry and in the legal advisor's office, the bookshelf had a few books in Finnish, also in German, and the one English language book was Oppenheim's International Law, volumes 1 and 2. Oppenheim, all legal advisors of foreign offices know is the handbook. Its 9th edition today, and the 10th is underway to being produced, is the first thing lawyers look at in the Foreign Office when they need to deal with the legal question. And here is the understanding that has been conveyed in the 20th century through Oppenheim's international law. In international law is the law of civilized states, which he understands form a family of nations. It's a very romantic sense. A society of nations, a society as a family of Christian and civilized nations. Of course, that idea, the idea of European civilization, the idea of a family of nations, was badly hit by the First World War, to say the least. And in the interwar era, lawyers who identified themselves with a social strand in legal studies, not exactly what the Center of Social Legal Studies now does, but lawyers who are worried that this state centrism, this formalism, is insufficient to operate as a powerful element in the way we are governed, looked into alternatives. And those alternatives was about having to identify interests and trying to put those interests in some sort of a configuration that would satisfy everyone. E.H. Carr, one of the founders of international relations as a discipline, ridiculed famously that idea, the idea of harmony of interests, that liberal utopia, that there is a way, a scientific way, somehow to calculate everybody's interests so that everybody has, and legislate on that basis so that everybody has an interest in following the legislation. The most well-known and influential of this strand was functionalism, legal functionalism, as put forward by David Mitrani in The Progress of International Government from 1933 and subsequent writings, so that the League of Nations, whenever people in the League of Nations needed to find justification for the complex operations of the nations, they often referenced Mitrani and spoke a functionalist language. We are here because we have this we are united in the purpose that we have, and we have these technological means. So we no longer care too much about politics. Instead, we direct our attention to techniques, economic techniques, but also other technologies of communication, technologies of traffic, etc. And through focusing on these apolitical, or if not anti-political, ways of operation, we can bring Europeans and the world together. That was the interwar idea. Hans Morgenthau is conventionally known as the founder of the discipline of international relations in the United States. This book, Politics Among Nations, published in 1948, is still the most widely read political science book in the world. I think it's also in the 9th edition by now. It puts forward a standard realist position. I'm not going to go there. Morgenthau was educated in Frankfurt. He was educated as a lawyer. His PhD thesis was on the nature of international legal norms. And the thesis was very well received, and the thesis of that work was that the reality of international norms depends completely on sanctions that support them. So it's a criminal law, very commonsensical idea of the law. Law has reality and existence and validity to the extent that there is a system of sanctions. And therefore, he looked at international law in the interwar. He didn't see much of a system of sanctions. There was in the League of Nations a formal system, but the system collapsed in the context of the Italian attack on Abyssinia, when European states regarded it as more important to prevent the Mussolini-Hitler alliance to be consolidated than submitting Italy on meaningful sanctions. Mussolini said, well, if you sanction me, I regard that we are at war. And the Europeans thought a second time and didn't put Italy under sanctions, so the system collapsed. Morgenthau, as I said, was a lawyer, an international lawyer. In 1933, he left Frankfurt because of his Jewish background. He went to Switzerland, to Geneva, where he resubmitted the same thesis, slightly differed, in French, La réalité des normes, en particulier des normes de droit international, and he was rejected by Paul Guggenheim, a fellow Jew. He asked for a second opinion, though, as you would do in this, and because Switzerland, half of the population of Switzerland seemed to be refugees from, or legal refugees from Germany, his second examiner was Hans Kelsen, and Kelsen immediately accepted Morgenthau's ultra-realistic understanding, so that politics among nations, the realistic understanding of international world, is dedicated to Hans Kelsen, the most formalist of the formalists in the international legal field. But Morgenthau, before he left international law, he moved to America, but to the United States. In 1940, in the American Journal of International Law, he attacked international law. He attacked it for two reasons. In the one side, international law was not real and not scientific because it was not based on empirical studies. Empirical studies were needed in order to understand and cope with international governance. And secondly, nor was it morally anything. It had no moral conscience. It had made no studies of ethics and mores. It had no concern about legitimacy. So, two criticisms coming, in a sense, from opposite directions: empirical direction and morally oriented political science direction. International law failed both of these texts. It was nothing. And so politics rules among nations. But not everybody was discouraged. And here is Julius Stone. Julius Stone, who was a professor, was a student at Harvard and a realist, a legal realist, became a professor in Australia at the University of Sydney, and in the 1950s became well known as somebody who tried to do empirical work in international law. These are his lectures at the table of contents of his lectures at the Hague Academy of International Law. At the Hague Academy of International Law. And at the end of these lectures, he noted that, well, actually, it's not possible to do empirical work in international law because empirical work, as he understood it, was about interviewing people engaged with international law. And the people engaged with international law are diplomats. And it's no use to interview diplomats because they lie to you. And so there was nothing to be done. Now, the story doesn't end there. In the United States, as we know, there were efforts to bring social studies and international law together. There was the empirical direction, international law and the social sciences, a well-known book by Wesley Gold and Michael Barkun, which takes the language of systems and units and communication and uses these empirical social science vocabularies, systems theories, in order to redescribe the world in a political science vocabulary. Way more interesting is the Yale School by Harold Laswell, Maurice McDougall, and others, who created this complex set of neologisms in which a scientific view of international law would have to start with a description of the political context. It would have to list perspectives, participants, their basis of power and situations, and it would have to make a commitment, a normative moral commitment to basic values: power, wealth, affection, skill, enlightenment, well-being, and rectitude. And at the heart of all this is the authoritative decision. This is US foreign policy written in a neologistic legal vocabulary. At the heart of the law is the authoritative decision. That's also a well-known German idea. That authoritative decision should be based upon or reference certain moral ideas. Chuck, 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 chuck. Those moral ideas should be made as concrete as possible by looking back to whoever is what the context of the elaboration of any decision making is. It never went, international lawyers put McDougall's work always in a footnote. It's well known but has no influence whatsoever. The English school is perhaps more influential. Here is Hedley Bull, the anarchical society embodies this idea from the 1970s. That the international society is something. It is out there. We should be able to operate our social science techniques towards it as long as we understand that it has this special quality that it's an anarchical society. It is anarchical, but it's not completely anarchical in the sense that there are a certain number of states conscious of certain common interests and common values that they conceive themselves to be bound by a common set of rules. This is the way I read this is a reinterpretation or a restatement of the original idea of international law as a law between civilized states and a family of nations who subscribe to certain cultural understandings, which is to say that their diplomats are able to speak to each other, dress with ties, and shake hands when they meet, or maybe more. But it was very influential in international law, so that the long-term president of the Max Planck Institute of International Law in Heidelberg, Hermann Mosler, took it as the heart of his lectures in The Hague, the international society as a legal community. Now, Mosler is the first German, that is to say, federal German from the Federal Republic of Germany, who in the 1970s and 1980s then speaks the voice of a new Western Germany, and who becomes a member of the European Court of Human Rights in Strasbourg, becomes a member of the International Court of Justice at The Hague, and declares this new German understanding of international law as a legal community living in an international society. Hedley Bull's ideas about anarchic society, which nevertheless recognizes certain cultural values, as well as Hermann Mosler's idea of a legal community that expresses those common values of what then is a larger society in the process of unification, are very similar indeed, but also extremely superficial. The idea has more recently been expanded so that the followers of Hedley Bull, the English School of International Relations, based, I suppose, in part in this place, but also in the other place, the expansion of international society, which in a more, how would I put this, more politically correct or woke fashion, brings the idea of international society into the developing world, or the developing world into that understanding, as well as looks into the ways in which the undeniable fact that places like the United Nations and other important actors in the global scene seem to be able to rehearse a common culture. Nevertheless, the most important person in the 20th century in terms of law and society in international law is Wolfgang Friedmann. He's a law and society person. He's a legal philosopher, a posthumous recipient of the lifetime award by the American Philosophical Society, a serious thinker who in his book, The Changing Structures of International Law in 1964, said pretty much the kinds of things that I have been saying today, but in a much more diplomatic way, and in a sense, much more constructively. He brought forward this understanding, 1960s understanding of law as an instrument of social order, and therefore closely tried, as he put it, to the structure of society. It's not just about what states do, even less what states will. It has to do with economic cooperation, welfare creation, development. It has to do with human rights. He saw the European Economic Community, as it then was, as an incipient form of European federalism and possibly also of a global federalism of a particular kind. He was into expanding legal thinking about development. Law and development was one of his themes, and he was really influential in the UNCTAD, the UN Commission on Trade and Development, that was set up also in 1964 to organize and to propound the new international economic order, something that Friedman also had a great interest in. So an alternative that might have been, but didn't, because of a recent history that we all know, 1980s, Margaret Thatcher, Ronald Reagan. I was one of the people who came to the most important process of the new international economic order, named the Great Law of the Sea Treaty process at its end in the early 1980s. The idea was then the Nordic countries, together with many of the developing countries, to create an international order of the oceans. This order would embody an international seabed authority situated in Jamaica. The International Seabed Authority was supposed to start deep seabed mining, the famous nodules, manganese nodules, and to become this public enterprise that would sell the minerals received from the deep seabed, and all the profits from these operations would be then given to the developing countries as development assistance or however. In 1982, I came in. That was the time when the Law of the Sea Convention was ratified in Montego Bay in 1982, when Ronald Reagan says, oh, well, it's true, we've been participating in this process for 8 years to get these rules going, but I don't think we will participate in this. And following was the British, the Germans, the French, and thus started the 12-year process. The 12-year process through which the Secretary General of the United Nations, under the vocabulary of securing the universality of the convention, securing the universality of convention, the Secretary General tried to convince the Western countries to come back to the convention, and they did once they had renegotiated that part of the convention that dealt with its economic activities and especially the establishment of the International Seabed Authority. Society becomes a market, as we know. So the famous 1997 World Bank report on the state as a facilitator of private activities, the state as this neoliberal operator, as part of the market, not of the market, but as part of the market, and seeing to it that the market will operate in accordance with rule of law, individual rights, and all of that. 1990s, the language turns into a complex speech about governance, pluralism, transnational law, fragmentation, I was appointed to the International Law Commission, which is this UN body dealing with the codification and progressive development of international law, and was assigned to do a report on the fragmentation of international law in 2002, because the successive presidents of the ICJ, the International Court of Justice, had been speaking to the General Assembly of the United Nations with great concern over the fact that the field is fragmenting. It's no longer just international law, but it's international human rights law, international trade law, international investment law, international environmental law, international sports law, and so on, and so on. You could understand, obviously, that for those people who sit in The Hague, those 15 and elderly persons, that they saw the mountain at the top of which they were sitting crumbling down, and these other precipices being created along the side. Fragmentation, deformalization, and so on. A wholly different description of the world, which as a description meant legitimation or an opening of door for legal regimes of the most varied types. And this is my last slide. The last time I've had a conversation on this was when, together with my colleague David Kennedy from Harvard, we tried to make sense, having worked in this field for many decades, as what was going on in this series of conversation. And what the best thing that we could propose about the nature of the social in the international is that it is a struggle. Who can define or redefine what the social consists of? And what is law's power in that struggle? We thought the power was twofold. On the one hand, law frames an idea of society. It isn't a creation of society, it creates society to us. It creates us. If you have an environmental lawyer who one morning opens the window to the world, that lawyer is bound to see environmental problem all over the place. Now take a trade lawyer, bring her to the same window, she opens the world, and it's subsidies and tariffs that she sees. Or a human rights lawyer opens the window and it's human rights problems, it's torture, it's genocide that they see. So the social is a creation of legal vocabularies. It's a creation by ambitious professionals of what it is that in which they are the experts, that thing is what the society is. Framing, but also articulation. For law is everywhere. Law in the international world, nobody can lift a finger. Nobody can travel anywhere, nobody can receive any stuff, nobody can watch any movie without a huge amount of legal rules constantly operating out there. This is a banal truism that most international lawyers have been accustomed to stating to skeptical journalists who say, well, this international law of yours isn't really operating, is it? But they have not, we suggest, taken seriously enough the omnipresence of law. The omnipresence of law, which has also led to the retreat of politics from places, a retreat that many people regard as rather problematic. The legal power as the power of legal experts. Now, what is that power? That is the power to be able to say something as a legal truth. This is the truth of environmental law. This is the truth of trade law. This is the truth of human rights law, and so on. But not just to state the truth, but to state the truth in a situation where you expect that others should yield to the truth. The society is a hierarchical arrangement in which some people are able to tell things as true, whilst true in a hard social fashion, whilst other people are expected to yield to what it is that they say. And so I finish with this suggestion that The world of the social is a world in which experts are constantly articulating and re-articulating the social in terms of their expertise, so that we become the ones who can state the truth of the world, but not just as an abstract scientific truth out there, but in such a way that other people would have to yield to it. Thank you very much.